Good afternoon, everyone. It's a great pleasure today to welcome you for this seminar on Sámi rights and jurisprudence. I am Dorothée Cambou and I'm assistant professor at the Faculty of Law at the University of Helsinki. And today we will have a seminar on Sámi rights jurisprudence. As I begin this presentation, this introduction for this seminar, I would like to say a few words about the larger project that is behind the scene of this event. We have a project on Sámi rights and sustainability that is funded by the Nordic Research Council. It's a collaborative project that focuses on the progress and challenges raised by the implementation and recognition of Sámi rights in the Nordic countries. This project organized a series of workshops that are implemented by the North-Seal network. And the North-Seal network is a network devoted to the study of Sámi and indigenous people law. So today we have decided to host a public event to raise awareness about the challenges regarding the recognition and implementation of Sámi rights in the Nordic countries. And we have decided to focus on three important and very recent Supreme Court cases, namely the Girjas case from 2019 from the Supreme Court of Sweden, the Fosen case from the Norwegian Supreme Court from 2021, and finally the most recent court case from the Supreme Court of Finland in the Tenojoki case. For this occasion, we have invited three leading experts in indigenous and Sámi rights, namely Professor Mathias Oren, who is a professor at the University of Tromsø and also an international renowned scholar on indigenous people rights and international law. Professor Oren has also served in the past as president of the Sámi Council. He has also advised many lawyers in litigation concerning Sámi rights and also acted as an expert witness in the Girjas case. Next, we have Professor Øyvind Ravna, who is also professor at the University of Tromsø. He's the head of the Sámi law group at the University of Tromsø, and is an international expert on indigenous people rights, Sámi rights, and property law. Finally, we have Åslat Holmberg, who is also among us, and is a vice president of the Sámi Council. He's also a former member of the Sámi Parliament of Finland, and he has been also acting as an expert in the Supreme Court case from Finland that we'll discuss later today. So I will not hold you too long, and I will give right away the floor to Professor Oren. But before doing this, I just wanted to say a few words about practicalities. Today, this is an event that is live, so this means that we will have also a question coming both from the audience here, but also from the chat. We will give 30 minutes to each presenters to give their presentation, and at the end of each presentation, we'll get maybe a couple of questions, but we will organize a panel discussion at the end of the three presentations, which means that you can also ask more questions at the end of the three presentations. Please ask questions in English unless it's not possible, and if this is not possible, please let us know, and we'll have someone translated the question from Finnish into English on the chat. So thank you for being here, and thank you for presenters for making the trip to Helsinki today. It's really a pleasure to have you here today. Thank you. So please, Mathias, the floor is yours.
Thank you very much, Dorothy. How do I put this into play? Thank you. So, as Dorothy said, I will speak a few words about the relatively recent ruling by the Supreme Court in Sweden on, or in the Girjas case, which I think also, given that the law in Finland and Sweden are so interconnected through history might be very relevant here, should such a case reach the courts in Finland as well. I've been given a little time, and the presentation will have a background, the case, the legal subject, the findings of the principal importance of the ruling, implications, additional significant notables, and what does this mean for the future, this case, in Sweden and perhaps beyond. The background of this case, I think, should be noted, because, and this also goes to Finland and the all other Nordic states, that there were really no interest in reaching conclusions on the Sami land rights, and in particular, in this case, the reindeer herding rights, through the political arena. Incapacity or unwillingness, others can judge, but nothing came out in the political process. And it's really forced the Sami reindeer herding communities to go to the law, to go to the courts, to see what they would say, what rights they hold to the rights that they have always used. And once they had decided on this, they had to determine, okay, we're going to go to the courts. So how do we do it? What is the case that we want to bring to the court when we now, because all the reindeer herding communities came together through their organization to say, okay, let's test this. The Swedish politician says we have no rights, we're going to test this. So how do we do it? What kind of case do we want to run to see if we have more rights than they tell us? And the case they chose had to be principled rather than practical. They wanted to have the principles tested rather than some specific, can I fish in this particular pond? They wanted to have the principles tested. They also realized that if you're going to do this, you're going to face a court with Swedish lawyers. And I would say later on, that fear perhaps was a little bit overstated, because the courts were fair to the reindeer herding communities. But they wanted we should not ask for too much in the first step. We can then go to court again, but we want to have a case now that we can win without too much psychological breaks in the heads of the jurors that would be, after all, Swedish. And based on this, and it should be manageable. I mean, it should be a case that could end within a reasonable period of time, within a reasonable cost. And taking these things into considerations, the reindeer herding communities opted for the Girjas case. And I think this bears pointing out, because later on, now when the ruling has been delivered and so on, it's been so much about who can sublet hunting and fishing. That was not what Girjas was about. That was not what Girjas was about. It was about to get the principal case, to see, to test what are the rights of Sami reindeer herding in Sweden in general. The The hunting and fishing, the subletting in particular, was secondary. I don't think it was so thought about so much the ownership right issue. It was early determined, I think, from the Sami community side that we're not going to fight the ownership right in this case because it would just be too much, both in work, in resources, and also in the mind of the resistance of those you're going to face. But I think, and I will get back to that, but actually the Girjas case nonetheless settled the ownership issue in the Sweden mountainous areas. So, the case was really about the Girjas case. What the reindeer herding community claimed were exclusive usufruct rights to small game hunting and fishing in the mountainous parts of their traditional territory. They also claimed the subletting part or the component, but that was not material. It was just there because we have a legislation in Sweden that says that the state now sublet the hunting and fishing, or small game hunting and fishing, to be precise, in the mountainous areas of the reindeer herding communities. But that was not a big issue in the case. They claimed the exclusive right to hunting and fishing. The subletting was just a tag on. And they correspondingly claimed that, and that's where you get this subletting in, that the state has no right to hunting and fishing in these areas, and the state has no right to sublet these material issues, given that those vest in the community. To support this claim, Girjas Sami reindeer herding community submitted two legal grounds. One was that this followed immediately from Swedish law. This became close. They lost on that one with the ruling of 3-2 judges. The Supreme Court was divided on this issue. I think I can say, as a little bit of an insider, no one thought that it would be that close. And had the court ruled on the legislative ground, we will not see the principled decisions that they're going to speak most of today. Then it will just be on the law, an interpretation of the law. And the case would have, the ruling would have much less impact as a precedence. But the court was split, and in the end, they ruled 3-2 that no, there was no support in Swedish law as you interpret the letter of the law for the ruling in the Girjas case, that the rights vested in the Sami community as claimed. So it would all, and this is what I will be speaking to for the remaining of the day, the second ground, which is protected use, that the Girjas community had used this land from time immemorial, more or less, and therefore hold the right to exclusive rights to the natural resources in the area, including, if they should show this, to sublet. So I would say, the case in a nutshell in the Girjas case was two things. Could, in Sweden, according to Swedish law, the Swedish law on property rights, this kind of use of extensive mountainous areas result in an exclusive usufruct right? Because that's not in Swedish law until the Girjas case. Then it would be, had to be, and I would imagine it's the same in Finnish law, very definite areas used for agriculture and those kind of purposes to establish these kind of rights. The Girjas case asked the court, can we, as a reindeer herding community, in the way we use the land, establish the same kind of rights as agriculture can, Swedish agriculture? And should that be the case, yes, and this I think is an aspect of the case that got a little bit lost. If that is the case, who is the holder of the right? Girjas, as a Sámi reindeer herding community, said we are the holders of the right. And they based that claim on two, kind of, that they have the right from two particular sources. One, their predecessors, I mean Girjas, they were formally established in 1886 under Swedish law, but the community go way back beyond that. Can they rely on that use? Secondary, if not, could they rely on Sámi use in general? These are, I think, the two issues in the Girjas case. One, could Sámi use, reindeer herding use of an area give the rights that the community claimed? Could, if so, the community be the holder of the right? The problem, or possible problem, the potential problem of the second is that, as I said, the Girjas, and I will not get into details, but it wasn't even Girjas then, but Sámi reindeer herding communities were formalized or established in connection with the first Reindeer Herding Act in 1886 in Sweden. And Girjas claimed that they had existed beyond that, and they were a legal subject before the law. But they didn't really push this in the case too much. And I would say that this was, as I put there, the lumbering large in the ruling. Could Girjas rely on their predecessors, the denominations that they had under Swedish law prior to 1886? And if they could not, could then they rely on the use of generic Sámi? Just Sámi use in general. But then comes the implication, could generic use of Sámi give rise to an individual right for our community? The state vehemently contested this, and I would say understandably. Why should generic use of Sámi give rise to a right for a community? But these were the two grounds upon which that Girjas said, we hold this right. I will get back to the second one, this one I just discussed on the legal subject. First, I'm going to discuss the principal rulings in the case, what led the court to rule the way it did. So what the Supreme Court and the Court of First Instance and the Court of Appeals had to address, in my view, was first and foremost, can use of lands, waters, and natural resources common to summer and reindeer husbandry establish exclusive property rights to large areas, to extensive areas? This had not been settled in Swedish case law before. It had been settled that the Sami, based on this kind of use, has a generic right to use lands for reindeer husbandry where they have traditionally done so. Very much in line with the Selby case also in Norway, where it was established that, yes, you have the right to use your land for reindeer husbandry, for grazing, but it's not an exclusive right. It's a right to use where you have been. What the Girjas case asked of the Swedish courts were, are we the sole users? Are we the only ones that can use this land? And that had not been tested before, and for Girjas to be successful, they had to convince the court that based on, they had to adjust, culturally adjust the criteria that are normally applied for how you establish rights to land through protected use to Sami customary use. They asked the court to say, we are not Swedish, we are Sami, and we use the land in this way. And when we come to the court and ask, do we have the right to this land? You should apply what follows from our traditional use and not what is common to Swedish normal law. You have to change how you think about these criteria, how you establish rights. That was what Girjas asked of the Swedish courts and ultimately of the Supreme Court. Again, the Swedish government, the Swedish state, vehemently objected to this. They said, we should apply the law as it has always been in Sweden. We should apply the law as we do to Swedish citizens, regardless if they happen to be of a Sami background. For Girjas, I mean, that would be the starting point. That is the starting point. You apply the law equally to all. For Girjas to win this case, they had to break through this barrier and say, no, you should apply the law based on who we are as a Sami reindeer herding community. That was what they asked of the courts. There had been precedents in Sweden before this, and as I said in Norway, that you have to adjust the criteria for what establish rights to land resources to Sami use. But that had been to use in a relatively limited sense. You have the grazing right together with other uses. And basically, if you are challenged, you have to move. What Girjas asked in this case, different to the previous Nordmalen case in Sweden, different to the Selby case in Norway, was that we are the exclusive holders of this land based on our traditional use. That's what they asked of the courts. attacking this issue, the Supreme Court took a step-by-step approach. It established first that nothing in Swedish law precludes, in principle, that you can hold these kind of rights to mountainous areas. It established that, yes, there is nothing in the law of Sweden that says that this right cannot exist. And then it said, okay, so when investigating if this right is there, then it must not be, and this is actually, I get back to that on the importance of international law in the case, but this is very much in line with international law. It says that the right, if it is there, and we have established that, it cannot be theoretical, it should be practical. It must be there also for some reindeer herding community. And that means, the court said, that we have to see and adjust the criteria that's going to be applied to see if the right is there to this particular case. We cannot just use it as we always have done with respect to Swedish farming, Swedish agriculture. We have to now see if we now have said the right is there, and it should not be theoretical, we have to see, is it there for some reindeer herding as well? And I think this is but this is the critical juncture of the case, where the Supreme Court decided that, yes, we need to do this, and then we need to adjust to how some reindeer herding is actually pursued and to the environment where it is pursued. Meaning that if a Swedish farmer plow his land and so on is very delimited, that's not the way some reindeer herding is used or exercised. It's done in a very different way. And if we're going to try, if some reindeer herding has established right, we have to have as a point of departure how some reindeer herding is pursued. And this, as I would say, is the critical juncture of the ruling in the Girjas case. That they decided, yes, we will not be deflected or think about that this will then establish rights to enormous areas, a large part of Sweden. This is the way the Sámi reindeer herding has used the land, and we're going to base our judgment on whether they have established right based on how they use the land. This is the critical juncture of the of the ruling in the Girjas case, I would say. And it goes back to what I said in the beginning. They ruled this, and this is kind of got lost somewhat in the aftermath of the Girjas case. They based on this on how reindeer herding is pursued, the grazing rights. And then they said, the Supreme Court did, that this will then also apply to hunting and fishing because it's so associated with the reindeer herding. So when they had established this rule, it's voluminous in the ruling, but I think that is, in my view, the court is a court, it has the right. But I think when they had established the principle I just said, the ruling was there. The rest was just applying the norm. So they concluded, the Supreme Court did, that yes, Girjas, and this was not evidence case, it's quite a lot of evidence in the ruling, but I think it was set from the beginning. They had ruled, they had used the land. The court knew this. And they said, yes, they have used the land. In principle, it's they have established the right to hunt and fish and other ways as well, as I get back to. For the right to be exclusive, as Girjas community claimed, it had to be dominating as well. The court found as well that yes, it was. There were very little competition in the land uses during the time period when the right was established. In Swedish law, to establish right through protected use, the use has to be visible, which could be a problem for Girjas because this is a mountainous areas. There were very few people there, except the reindeer herding community. The court ruled we cannot apply that norm when it comes to Sámi reindeer herding rights, simply because they were there first. There was no one there. So they adjusted that and that criteria as well. Then they concluded, had there been objections, that would have been a problem for the community, but they said there were no objections. On the contrary, it seemed throughout history that there was an established understanding that the Sámi had these rights. So the court, in conclusion, established that the principle they had put in front in the beginning, when they looked at the criteria, the factual criteria, they were there. So they had established that there was an exclusive right of hunting and fishing for the Sámi during that, or historically. Then, and I said in the beginning, I think it's a little bit unfortunate that now when we talk about Girjas, it's become so much about subletting, because that's not what the case is about. And it's partly the fault of the Supreme Court. And I get back to why this happened in a moment. But already here, the court had found that Girjas was the sole, no, not Girjas, sorry, but the Sámi had the sole right to hunt and fish in these areas. The court went into the understanding of, did this right include the subletting right? And for some reason, they tried this separately. I mean, if you have an exclusive right to the areas, it will normally include the subletting component. That's part of the property right. For some reason, the court found it necessary to investigate this separately. In any event, it's not crucial. They came to the conclusion then that it did include the subletting part. But it's strange that they felt the need to investigate this separately. And why did they do this? And it goes back to what I said at the second part of the case in a nutshell. Who is the holder of the right? Girjas claimed, first and foremost, that they could rely, the community, on their predecessors. I mean, Girjas, it was formally established in 1886 with the enaction of the first reindeer grazing law in Sweden. But the community had existed as long as we know. And Girjas said that we can rely on the use of our predecessors. Swedish law might have called them differently, but we have been one reindeer herding community always. The court seemingly did not find this convincing. So they had to find another way. See why Girjas had these rights, the community. And Girjas had also, as I said in the beginning, claimed that they could also rely on the use of Sámi in general, generic Sámi. And this was what the court picked up on. They said there have been some use of this area as long as we know. When this community was formalized in Swedish law in 1886, those Sámi, individual generic Sámi, that have been using the land since time immemorial, they become members of the Girjas Sami reindeer herding community. And in that moment, the right transcended from them being holders as generic Sámi to them being members of the Girjas Sami reindeer herding community. And since when it comes to subletting, you cannot have individual persons doing that. That would create chaos. That must be handled by the community. So the Supreme Court said that part belongs to the community, the right to sublet. And that allowed them to conclude that the Girjas community has owned the right, that they had the right, they have won the case. I've been warned that I have a little time left. So what I want to conclude with is that I started with saying you should look at the end part of this slide. What I would like to conclude with is that it was a very deliberate choice from the Sámi reindeer herding in the Girjas case not to include the ownership issue, because that would have made a case, it would still be ongoing. You would not see a ruling within the next 10 years. They decided not to include the ownership right for tactical purposes. But I think that the ownership right issue was settled with the Girjas case. It's quite clear from the ruling that Girjas or any other Sami community will have great difficulties claiming formal ownership right of mountainous areas in Sweden. I think more or less that the Girjas ruling says that's not going to happen. But what Girjas won, and what I would say more or less all other Sami reindeer herding communities in Sweden have, because formally, even if the Supreme Court made this detour of the members, It's still the community in practice that hold the right. All reindeer herding communities in Sweden, mountainous reindeer herding communities in Sweden, hold all the aspects, all the elements that are including in ownership right, except the formal ownership right. The Girjas case concerns small game hunting and fishing, but it's evidently that all other renewable resources that are in those areas, including moose hunting and so on, will vest with the community as well. There are no legal reasons why the precedent in the Girjas case will not apply to other renewable resources. So I would say that the Girjas case, it's settled the ownership issue. The state is still the formal owner, but the state has no rights that follow from formal ownership. They all vest within the reindeer herding communities. That's the implication of the Girjas case. Thank you, and sorry for taking a little bit much too time.
Thank you, Matthias. Able to take maybe one or two questions from the audience. And in the meantime, we'll get ready for the next presentation and maybe change the table from places here. One. Yes, please.
Thank you, Matthias, for a very interesting presentation. As you know, I commented the Girjas case on the Swedish radio, and I commented during the process that the ownership question was the elephant in the room, because I found that some of the obvious things the Girjas claimed was proving that they also had ownership. But the reactions I got from lawyers was that that had to be another completely different court case, of course. But you are saying that the principles are, so to say, settled by the court. And I wonder if you can comment a little bit on just that part that experienced judges commented on my on when I was saying that it was some of the proof are for ownership of the land too, but they commented then that would be another court case with reference to what kind of proof had to be given into the court.
Yes, please.
Oh, wow, that's a big question. In my... Can I sit there?
Yeah, you can.
Yeah, in my view, as I said in my presentation, the elephant in the room was not the ownership question. The state tried to make it because they were basically saying that if we own the land, we have the rights that follow with the ownership rights. Girjas said the ownership is not important to this case. In my view, the elephant in the room was the legal subject issue. When it comes to the ownership, yeah, I mean, you're right. I mean, this again, the state tried to make this about ownership because it was part of their strategy that they wanted, if you are the owner of the land, you have the components that follow with ownership. And Girjas the community in the strategy and in the courtrooms, they did not want this to be about ownership, because, as I also said in the beginning, it was very early settled that if we claim ownership, we are taking on so much that it jeopardizes the win of the case. So they wanted to exclude the ownership issue. The state wanted to bring it in. I don't think, I mean, the court of Tingsrätten, the first court, was pretty preoccupied by the ownership issue. But I would say the Court of Appeals and the Supreme Court, I mean, the Supreme Court just dismissed it in one paragraph, said that in the ruling, that Girjas has not claimed ownership right, and therefore we will not consider it relevant to our considerations. How much is loomed, I don't know really.
Thank you, Matthias, for this response. I think we'll move on to the next presentation, and then we can come back to this very controversial question. I welcome to the floor now Professor Ravna. Please, I think we can. I will move this around.
Yes, thank you, Dorothy. Thanks for the invitation here. It's good that finally we able to speak live with people. What's also is interesting and probably a good thing that all these three Supreme Court cases we are speaking about here is the cases where the Sámi win, and that is very seldom. Usually when I'm invited to speak, it's opposite. It's cases lost by the Sámi. And we have had many of them in Norway, at least which I could count on my hand from 2016 up to today, 5 Supreme Court cases. I'm going to speak about a Supreme Court case that have taken the Norwegian government and the Norwegian bureaucracy. But most of all, I'm speaking about human rights in Norway. The UN Convention on Civil and Political Rights and how Norway upheld it. And it's also clearly that there is not everybody among the lawmakers in the government and the parliament is satisfied with the development in Norway. The ICCPR, the convent, it's legally binding to Norway already back in 1976. And it was incorporated to Norwegian law with precedence in 1999. However, until October 11, 2021, Article 27 had far greater significance in theory, in universities, or in political discussions or negotiation than in any case law in Norway, in any court. But on that day, the Supreme Court of Norway, in a grand chamber decision, ruled unanimously that Norway's obligation under Article 27 has been violated. And the violation consists in that the Energy Directorate, a part of the bureaucracy in Norway under the ministry, has granted license for wind power plants in the pasture of 2 Sámi reindeer units, Sámi reindeer Girjas. The parties in the case was an energy company called Fosen versus the 2 Sámi Girjas. And also as a party assistant, a helper for the energy company, we found the Norwegian state. I'm come back to that because that is rather special when we think about who is obligated to uphold the human rights in Norway. Also, we should know that this case took place in the middle of Norway, or let's say south in Norway. It's in the southern part of the traditional Sápmi area. There is few reindeer units left there, so the reindeer herders in that area, they are in a particular vulnerable situation. The judgment, known as the Fosen case, is unique in Norway as it's the first time the Supreme Court has concluded that Article 27 is violated because of a physical intervention in Sámi land. The historic judgment is a result of an appeal against the case to determine expropriation compensation. It's not a case raised to test the law or principles or anything, but when the question about compensation, money compensation, come up, the Sámi Girjas, they argue that the case was unlawful, it was violating human rights Norway was committed to. And the case is based on the fact that the Directorate of Energy gave permission to build wind power plants back in 2010. I will not go into the long procedural story. The case started in court in 2013, and actually it's have been one more time in the Supreme Court in 2017, where the Supreme Court could have stopped the case at first step, but they didn't do it. And that is also something to think about, because if they had put their feet down at that time, the wind power plant hadn't been. The main question when the case come to the Supreme Court the next time was whether the appraisal or expropriation case for measuring the damages as a result of an invalid built power plant had to be evaluated. So that was the case, if it was legal or not. And a key issue in the Fosen case was whether the courts in Norway really was able to recognize that the society at large violated Sámi interests, because they have done it many times and just got support from the court. I have not time to go into all of that case. Some of you know about them. Probably the most, I will say, shameful example, it was about another wind power plant built in the county of Nordland, where the Sámi reindeer herders in the Gyllenark reindeer grazing district tried to stop the case by using the legal means before it was raised, before it was built, but they didn't manage. And for trying to stop it, they had to pay to the wind power or the energy power companies' lawyers 1.77 million Norwegian crowns, or something like 180,000 euros, just for compensation to their lawyers. That's the way the energy company stop reindeer herders to argue, because you risk to be personally ruined. Yeah, I will not spend much time on ICCPR. It's in a general human right convention established to protect general political rights such as freedom of speech, personal security, equality before the law, and so on. But there is also a particular article to safeguard minorities and indigenous people, which you can, I will not spend time on reading it for you. And assumed breaches of the article, if the national remedies are exhausted, they can be brought for the UN Human Rights Committee, which the Supreme Court, at least in Norway, will follow. Of course, you have to reopen the case, but in that case, the Supreme Court has a tradition to follow. The case we are speaking about here, there had not been any reason to bring it further to UN, because the Supreme Court themselves have taken the role of the UN Human Rights Committee. And what is the basis for the Supreme Court here, the legal source? It is the practice from the Human Rights Committee. There have been 3 cases here in Finland, the 3 Länsman cases. I will not go into them either. The most important here is, in any case, the Puma case from Peru, which consider an indigenous people up in the Andes mountain, the Aymara people. And where the Human Rights Committee found that the state of Peru has violated their rights, because draining an area for building a water supply system, so they could not feed their animals, their llama anymore, and do their husbandry. I will not spend much time on that case either, but at least one thing is important from the Puma case. And reason to speak about the Puma case here, it is because the Norwegian Supreme Court more or less copied the Puma case. And as you can see from the slides here, there is 2 criteria who is important. That the indigenous people or the minority should have the opportunity to participate in decision-making process in relation to these measures, and that they will continue to benefit from their traditional economy, for example, reindeer husbandry. If you can not answer positive with these 2 questions, there will be a violation. And in addition to participation in decision-making process, the Human Rights Committee states that participation must be effective, which not only involves consultation, but that the members of the minority gives their free, prior and informed consent. So that is important to remember. In the Fosen case, the Supreme Court didn't go that far because the intervention in any case violate the reindeer herders' possibilities to benefit from their economy. The ICCPR has been applied by the Supreme Court in Norway many times before. In 4 cases prior to the Fosen case, the threshold set out in ICCPR has been assessed and discussed by the Supreme Court, but not found to be violated. I will not go into that cases either, but at least there is there is 3 points we can take out of the previous case. First, that the Sámi in Norway are covered by the protection of Article 27. Second, the extent of intervention is important for whether there is a violation. And third, that the provision cannot be applied to internal reindeer husbandry regulations. This is this so-called Girjas Sami case, which was the Supreme Court's conclusion from that. So, about the Fosen case and what is important from that. The Supreme Court, they also hear copy from the Poma case of the Human Rights Committee that if a case have a substantive negative impact on cultural enjoyment or cultural exercise, there will be a violation. So it's not necessary, also as you point out in your book, Matthias, that there should be a denial. It's enough that it is have a substantive negative impact. And that is also what the Norwegian Supreme Court count on. In addition, the interference must be seen in connection with other measures. If there have been a lot of activities, infrastructure and so on before in the area, it means that it should count less before you pass the threshold. And in practice, the threshold is passed when a member of the minority no longer is guaranteed an economical outcome. The economy of the husbandry is therefore relevant in a discussion of a possible violation. The relevance must be assessed specifically in each individual case and must depend, among other things, on how the economy affects the cultural practice. In my view, this is it's the leading judge saying, the rights in Article 27 are in any case violated if a reduction of the pasture deprives the reindeer herders of the possibilities to carry on a practice that may naturally be characterized as trade. And we can see that the judges say are in any case violated, so it means that the threshold can be even lower than that. Also, there is no room for proportionality assessment. In this case, It was argued from the energy power companies that this was a part of the green shift and in such a way important also from other human rights convention. But the Supreme Court, they answered this arguing that the case cannot be balanced even against the green. Not everybody in Norway, and at least not the ministry, agree about that. Also, and what is very important with this case, and that is not developed from the Human Rights Committee, it is that the remedy measures must be culturally adapted or culturally sensitive. You cannot repair a violation by turning reindeer husbandry into something else. For example, in this case, it was a question about feeding the reindeer permanently hold the winter. The Supreme Court said that this was not an acceptable way to handle the case. There is also something about consultation, and what is important to remember about consultation, it's that you cannot consult away from a violation, from interference that will be a violation. If the interference is usually not, it's not possible to negotiate away from it. In other words, that the herders can receive money and say it's okay, and don't argue against the violation. And it's, as I can understand the Supreme Court, not even if there is a free prior and consent for the establishing, you cannot negotiate away from a violation if the violation is. This can, of course, be argued against, but I think it's rather clear from the judgment. Then I will come to the conclusion. What we can sum up from the Fosen case is 4 points. First, the court or the constructors, they have to evaluate the cumulative effects of the interference, seen what's have been done before and probably other plants in the area. The consultation extent to which the consultation have influenced on the decision, it's have significance, but it cannot make an illegal intervention lawful. The most important here is probably whether the minorities still have economical benefit from the traditional trade, and also that remedies or mitigating measures cannot be used if they derivate significantly from traditional Sámi reindeer husbandry. And then probably what is reason to the significance of this case. Yes, I'm soon finished. Will it have any impact on the Human Rights Committee's use of Article 27? Probably not. Could it have any significance on other countries with the Sámi people, as in Finland and Sweden? Probably. But what we really need to ask, what is the significance for Norway? one should expect that the Grand Chamber ruling, an unanimous one, should be followed up. But now it's 8 months after the judgment, and the wind turbines, they are still rolling around on Fosen. And not only that, at the same time, there is a new case coming up where the government is supporting the energy company. And the government is the responsible person for the human rights are not violating in the country. But instead of securing that there is not violence, they appear on the other side and arguing for a possible violation should not be violating. So I think I finished the case there, but it's really thought that Norway is not able to follow up that Grand Chamber ruling. Thank you.
Thank you, Øyvind, for your presentation. We have time maybe for one question, if there is nothing.
Thank you for your presentation. I'm Kukkaranta, doctoral candidate from the University of Lapland. I would like to know practical question of how the Norwegian government, are they going to make some decision of how the licensing legislation will be changed? I think this is what, for example, Davi wind power project have been waiting. And is there any estimation about time for the decision? And when possibly these new applications for wind power projects will be processed again? What is the situation currently in Norway?
Excuse me, are you speaking about a new law or just a new decision?
What I have understood from the news that the government is considering making some changes in the legislation process. Is that something that is going on, or what is really happening? Why we have been waiting for so long? What the government is thinking and planning? Maybe you can clarify this.
Yes, here is at least two different questions, but one is about the Expropriation Act, because today energy company they have the possibilities to start building before the final decision is made if the intervention is lawful or not. And that is because previously we had just the Expropriation Act to say that if you ensure payment to the person who is attacked by the intervention, an intervention will be lawful. But after the Norway adopted the Human Rights Act, this is not the case anymore, and that's what we see the result of in the Fosen case. So this rule about pre-accession, or what you call it, it I suppose will be changed. Because it's of course a really messy case for Norway to build a power plant and later find out that it's illegal. And the next, I suppose, it's what to be done with the Fosen power plant, and that is many people wondering about. But it looks like the government they are just hoping that they could go on and produce energy there. So about that, I'm not able to answer, and I don't think anyone except for the government or the ministry can answer that. But of course it is kind of shame for Norway that they are not able to following up a Supreme Court decision.
Thank you, Øyvind. for your response and presentation. We'll now welcome to the floor Oslat Almberg.
I think I'll sit here if it's okay. Yeah. Joo, no, puerre ehkä puhkaide. Mulla on skuvlailema asla neljäs asla tähän jomnasailla neljäs asla puolan njörkkänistä enuli eis. Sooma väini muhtin äppä solomui täppä. So, hello, good evening. I come from Njörkän, from the Tenojoki River Valley. And yes, it's good to see some familiar faces around here. And thank you for the invitation to come here. I'm honored to speak after two Sámi experts in law on their field. I am not a lawyer myself, but I've been working with Tenojoki fishing rights issue through activism and academia and politically as well. Why I wrote in the title Otsajohka and Virchajohka Supreme Court rulings, or Utsjoki and Vetsijoki, instead of Tenojoki is because these are two tributaries that flow to Tenojoki, and they are not directly governed by the same law as the fishing in the mainstream of Tenojoki. And what makes governance of fishing complex is because Tenojoki it's the most diverse Atlantic salmon in the world, with more than 30 different salmon stocks, and that means basically that almost every tributary or small river that flows into the mainstream has its own population, and the health of the salmon populations varies between the different streams. Okay, so here is a picture or a piece of art made by Outi Pieski. She has been also participating, supporting the court cases and our activism around the fishing rights in Tenojoki. This shows the whole watershed. As you can see, it doesn't show the state border, which does follow the main stem of the river Tenojoki. But this is in the Sámi heartlands. It's one of the very few places where Sámi are a majority of the population. And yeah, today it's divided by two states who govern the fishing with a bilateral agreement. So we Sámi who come from this river valley, we call ourselves Chatsekätte Olomot, which could be translated as people of the shoreline. And that is one way to describe how important the river and the salmon is to us. And it is basically because of the salmon why we have come to live in this area in the first place. And the significance of salmon has changed quite dramatically over the years. But let's say in the 1800s, early 1800s, it was estimated that just 1/6 of the population would survive without salmon fishing. And this is a subarctic region, so we cannot farm there. So actually salmon is our grain fields. So it is what is the basis of our sustenance in this area. Luossa means salmon, and when we talk about these court cases, it's very important to talk about the main issue, which is the salmon. We have experienced a strong decline in the salmon stocks, especially in the past few years, and at least my point of view is that in 2020 it was really a catastrophic year when we experienced a very low number of salmon returning to the stream. And it's important to keep in mind, as I mentioned in the beginning, that there are many different salmon stocks in the Tietno watershed, and some of them are doing much better than others. And that is significant because of the two court cases that we will look into. So, some background for these court cases. In 2017, we experienced strong restrictions on salmon fishing, which were imposed by this bilateral agreement between Finland and Norway. And these new restrictions, they targeted especially Sámi traditional fishing, limiting them based on some estimates by up to 80%. While new rights were given to outsiders or tourists, people who have built holiday homes in the region. So, as a response to these strong restrictions, there were 5 people who decided to break the law. They made a conscious decision that they will break the law. So there were 2 separate cases. There was one man who was fishing in Utsjoki, and he was fishing with a net in a period that based on these new restrictions it was not allowed to fish. So he was fishing in August, and then there were 3 women and 1 minor who were fishing with a fishing rod in Virtsajoki or Vetsikkojoki. So all of these people, they were fishing in their ancestral waters, and all of them committed that they had done so. They did fish in a time when it was not allowed to fish, or in a way that it was not allowed to fish. But they also denied that they didn't commit a crime. Actually, I'll go back to that. First in 2019 there was a ruling from the district court, the lowest level of the Finnish court system, which concluded that the Sámi had the right to fish in a way that they were fishing, even though that was in contradiction to the current Finnish law. Then the prosecutor appealed the case, and as it was a case of such principal importance, it went straight to the Supreme Court. And after years of deliberations, the Supreme Court finally gave their verdict earlier this year. And as you may imagine and see from the picture, that was a very, very happy day for us, and a result of years of struggles. And it is the first time in history in Finland that Sámi rights are recognized in this way. And it's also the first time that in Finland, in a case of a criminal court, that Sámi rights have been used as the main argument. So some things that are important to keep in mind when considering this ruling is the principle of proportionality, and I'll be reflecting a bit on how the Supreme Court is reflecting on the Finnish constitution and the cultural rights guaranteed for the Sámi based on the constitution, and then on the other hand on how we have the responsibility to look after our environment and make sure that the species are protected. and these have to be in proportion, that it cannot be that you highlight one too much over the other. Yeah, I'll jump back to this. So this is what the Supreme Court stated, that it is clear that the proposed regulation is detrimental to the pursuit of traditional fishing as a form of the Sami cultural heritage. So what the Supreme Court concluded was that indeed the Sami had a constitutional right to fish in this way, even though it was against the current law. And by doing so, they concluded that the act that governs fishing in the tributary rivers to Teno is incompatible with the constitution. It is so that if a provision of an act is in conflict with the constitution, then it shall not be applied, and that was the reasoning behind why the Sami were not fined, even though if they were breaking the law. And it is very important to keep in mind that the fishing was focused on salmon stocks in Otsejohka and Virtsajohka tributaries, which are relatively healthy stocks. There are some stocks in the Teno watershed that are in very poor condition, and some are doing much better. So it was key in this ruling that the Sami were actually fishing salmon that did have exploitable surplus, so they were not harming the ecological situation in the river. Yeah, so as the Supreme Court was evaluating the cases, they were looking into whether, in the case with the so-called illegal net fishing, they were evaluating if the limiting of the fishing season by 1.5 months to what it used to be was if it prohibited the Sami the possibility of practicing their culture, as is guaranteed by the constitution, and if this act indeed was in conflict with the constitution. And yeah, that is how they concluded it, that indeed, because in Otsejohka, where this man was fishing, as he argued that it was not possible for him to fish earlier in that year, in the period when it was legal to fish, because throughout the summer there was so high levels of water, high water levels, that his fishing spot was not in a good condition to fish, so to speak. There was too much water, so only in August the water level went so down that he was able to fish there. And yes, something that also has to be pointed out is, as you may know, last summer in 2021 was the first time in history that salmon fishing was completely banned in Teno and the tributary rivers. And what the Supreme Court argued was, or they concluded that this total ban on salmon fishing is irrelevant for this conclusion with the cases in Otsejohka and Virtsajohka, because the latter knowledge on the deterioration of the salmon stock was not taken into account, because the status has changed quite dramatically in the past couple of years. So they did base their conclusions on the Finnish constitution, and as it states in the Article 17, Para 3, that Sámi as indigenous people, as an indigenous people, have the right to maintain and develop their own language and culture. So this is the so-called fundamental right to culture, or protecting that fundamental right. And it is supposed to guarantee minorities, or as in this case indigenous people, the right to practice their culture. And as has been concluded by the Constitutional Law Committee, is that what is actually meant by Sámi culture is, or it includes, for example, reindeer herding, fishing, hunting, and they have also concluded in the Tenojoki case that salmon fishing is an essential part of Sámi culture in this region, and thus should be protected by the constitution. And also what the Constitutional Law Committee stated in 2017, when the new set of regulations was put to force, was that restrictions should focus on fishing that is not protected by this section 17, Para 3 of the Constitution, or Article 27 of the International Covenant on Civil and Political Rights, which is the right to protection of culture. Of course, however, that was not taken into account in that act in 2017, and the restrictions did focus especially on Sámi traditional fishing. So, what is the significance of this ruling? Well, quite simply put, it means that Sámi rights must be protected, that there is a threshold that you cannot limit Sámi rights below a certain extent. And the way I see it is that this is the first time that there is a Supreme Court ruling that directly underlines that the Constitution protects Sámi customary practices, which includes salmon fishing, as this case was about. And the way I see it, that this should have far-reaching implications for how the state relates to Sámi. It should have an impact when new legislation is being developed, that it has to be seriously considered what is the constitutional protection for the Sámi, and how to take that into account in whatever legislation that would be that has to do with Sámi culture, Sámi traditional practices. So in that sense, I see that this strongly strengthens the Sámi position in the Finnish legal system, and also has these political implications. So that being said, it is important to reflect this court ruling also in the legislation of Finland, and as has been ongoing attempt for years now to renew the Act on Sámi Parliament, which would at least slightly strengthen the Sámi position in negotiation situation with the state. That being said, I don't think Sámi Parliament is the right body to decide on fishing in Tenojoki. That should be done by the local rights holders. I also wanted to note that currently there are no Sámi rights in Finnish law, that all rights that we have, they are either tied to the place of residence or ownership of property, as is the case with the salmon fishing rights in Tenojoki. And this is the first time that, based on the International Covenant on Civil and Political Rights, Article 27, there is a conclusion that the Sámi do have rights that cannot be restricted. So what exactly are Sámi rights? one thing that is important to note that these are not the rights of all Sámi to fish salmon in Teno, but as the Supreme Court uses the term home river, that these people had the right to fish in their home rivers. So these were rights of the Sámi communities or even Sámi families to fish in the areas where their ancestors had been fishing as well. And this was the first time that that it was concluded that Sámi have rights. As I noted in the previous slide, in Finnish law there are no rights that pertain only to Sámi. So this was the first time that it's actually stated that Sámi have rights. So in that sense, Sámi were created as a legal subject. So one implication is that it has to be now figured out who are the Sámi who have these rights. How do you define them in each case? Yeah, I'll be concluding on this slide. I wanted to share some reflections, also comparing this to the previous cases that we have heard about. Like the Girjas case, it was about governance and territorial rights, who gets to govern hunting and fishing in that area. But compared to that, the fishing rights case in Teno, it was strongly on cultural rights and what kind of protection the constitution gives to the Sámi to, as they say, enjoy our culture. As I see it, an implication has to be that it's not enough for the ministries just to organize a formal hearing where they say that they have taken into account what the Sámi say and then decide whatever they want, because now we have a Supreme Court decision stating that you cannot cross a certain threshold, which would then deny the Sámi the right to practice our culture. And it is a significant step with the Sámi rights in Finland, but it is only one step, and if we consider the broader process of decolonization, then it must be noted that this case does not address the issue of governance as was in the Girjas case. And it does not address the issue that it is the Finnish courts and legislature and officials who do basically make the decisions on our customary resources and territories. So this ruling yet doesn't really give content in the Finnish context to the fundamental right in international human rights law, which is the right of all peoples to self-determination. So this is a case of cultural rights. So in conclusion, there have been some unofficial words that ministries have estimated that some 30 to 40 laws in Finland have to be renewed to highlight the conclusions or to be in line with the conclusions that were done in this Otsajohka and Virchajohka fishing rights cases. And even though this case is about this specific area and these two tributary rivers, then I see that it has a much larger fundamental meaning, and it does have impacts and significance way beyond Teno, because they are talking about Sámi rights. Yeah, I think I'll stop there. Kiitos.
Thank you. Thank you, Oslat, for your presentation. Before we open the floor for a broader discussion, I would like to target the first question directly to this presentation. So, please.
I have a brief question to you. Was it how unanimously did the Constitutional Committee took the decision? Mä voin suomeksi sanoa, you can then translate it to English. Kuinka yksimielinen oli perustuslakivaliokunta siitä näistä asioista? Oliko siellä erimielisyyksiä?
Joo, no tuossa on maybe, sorry, I'll answer in English. Yeah, so how unanimous was the Constitutional Law Committee when they were adopting these views? So I was referring to a few different statements of the Constitutional Law Committee, but especially when they were providing the remarks on the 2017 fishing regulations in Detnu, then they did vote on it, so they were not unanimous in that case. And that was the case when they were estimating whether this fishing act should be, well, I'm struggling to find the legal terms in English, but if an act is of special significance from the constitutional point of view, if it's limiting some fundamental rights, then there is a different procedure in the Finnish parliament, and it has to be adopted with a 2/3 majority. And the Constitutional Law Committee was debating on this, and they were not unanimous. So with this specific thing, they did have to vote on it, and I think it was one vote short that they actually, or the point of view lost that it should be done with 2/3 majority, but it was done in the so-called normal way of adopting the laws, which is by more than 50% majority. So there they were not unanimous.
Do we have other question or at this stage? No. Please feel free to ask question, but I have one question actually targeting all those different cases and therefore presentations. It's about the instrumentality of international law. We can see that at least in the Fosen and Detnu case, Article 27 played a major role in the articulation of the response to the judge. But I'm wondering if Girjas case also was built in relation with international law, if any justification were based on international law, or if it was only on the basis of national law.
That's a question for me, I suppose.
Yes.
It's difficult to say. I mean, the Supreme Court in Sweden was very eminent about that the ruling it was delivering should be in line with international law on indigenous people's rights. It repeated that in numerous paragraphs, but it didn't really say to what extent international law impacted on the ruling. It just said that we have to rule it like this because also that is necessary to make the ruling in line with indigenous people's rights. But it wasn't clear on exactly how much that impacted, I would say. But that said, there was one part I had to skip. I think that says a lot about previous cases in Sweden now, because the Supreme Court was so clear that Swedish law on Sámi land and resource rights should be in line with international law. That any case from now on those kind of rights would have to include an assessment of whether Swedish law is in fact complacent with international law on Sámi land rights. Can I just, now you took away, could I just add an observation. You took away the final slide, but
You want me to come back on
no, you don't
the
have
previous
to,
one? No, I won't be able, sorry.
Because, I mean, Assad said he is not a lawyer,
Mhm.
but I think he pinpointed an issue very, very well on the territorial versus cultural rights. How do you approach it? And in Sweden, at least from the reindeer herding perspective, the Sámi rights have been very much approached by territorial rights. In Norway, much more cultural rights. And the question is, which path is Finland taking? I think it's a very, very good observation, particularly for a non-lawyer.
Please.
Thank you. Thank you for your presentations. I'm Elsa Reimersson. I'm from Umeå University. Had a question. So you're describing some successes in national courts in the respective countries. And we have these connections to international law as well, in more or less, but in all three countries. But I wanted to ask if you would comment on what you see as the opportunities or possibilities or potential or likelihood of increased pan-Sami mobilization or, I don't know, streamlining of legislation between countries or other things that might happen, or if we should expect, or maybe it's actually better to do it within the confines of the states.
Yeah, maybe I can start with that. There are some efforts towards that direction, like the long time work with the Nordic Sami Convention, which would aim to harmonize the legislation relating to Sami in the 3 Nordic countries. And I don't know, maybe there are some small steps that have been taken on that field. So yes, I think that is a right approach to take to harmonize the legislation. And as we now have these 3 Supreme Court cases from Norway, Finland and Sweden, then I think these are really some strong building blocks on arguing also how the rights have been recognized in one state, and it should be not significantly different in the other state. And as Matthias was pointing out, the Girjas case is of special relevance to Finland as well, because Finland did inherit the Swedish legal system when Finland became independent, and the time when Finland claims to have gotten this ownership on the traditional Sami territories, then that is from the time when Finland was part of Sweden. So there is a lot of relevance, even if the case was in Sweden, but the background is very similar. Yeah.
Yes, just to add to that very briefly, the Supreme Court in Sweden in the Girjas case said that this right had been established at least in 1750, when Finland was a part of Swedish law.
Maybe I could say something on what we forget here is, of course, that in both these 3 cases, the lawmakers in the different countries, they have been on the opposite side. So what should we expect that they are willing to do? They are mostly trying to prevent this development. So, but at the same time, we could see that the courts, the Supreme Court, they are taking another approach now. But of course, the Supreme Court, they can say one thing in one case, and when they come new judges in the next case, you don't know what will be the outcome. So for me, these things very uncertain. But of course, I think go back to the Nordic Sami Convention probably the way to go, at least instead of just hoping for something and then there come a new court decision to turn the things down.
If I may just make a comparison here, what I see also as striking is that on the one hand we have Norway, which has ratified ILO Convention 169, but the Girjas case and Tenojoki case are strategic litigation, clearly to map what are the rights of the Sami communities. But if we compare to Norway, for instance, we have another established process, which is in the Finnmark Commission, and which is trying to map out all those rights. So I'm wondering if, comparatively speaking, it still makes sense to have a discussion about whether or not we should move on with the ratification of ILO Convention 169, or if the Sami Convention will fill this gap. Is it the reason why it's not happening in a sense in Norway? This gap is filled, so to say. I don't know if any of you can answer that.
Yeah, I think I should say for transparency that I was a member of the first so-called expert group that drafted the first version of the Nordic Sami Convention. And I'm very critical of the draft that is now on the table. I think it would take Sami back if that would be adopted. I also think that ILO Convention 169 is passé. It's legal history. I mean, definitely Girjas case that I know the most was ruled without ILO 169. And should we apply 169, maybe you would have a softer ruling. It's legal history in my view. I don't know about the Tenojoki case, but the right to culture is not part of ILO 169.
Yeah, you can say it's a legal history, but of course it is not a single example that it have been applied in Norway, even if Norway has ratified it. And I think among these three court cases, it's only in the Girjas case that have applied ILO 169. Because in Norway, both the Finnmark Commission, except for the last the Karasjok case, and the Supreme Court, they have interpreted it in such a way that it have not got the significance it should have. And of course, if you accept that kind of interpretation, then it's of course legal history. But if it should be read in the way that it was proposed from when it was adopted, I don't think it's legal history.
We have one question here.
Yes, thank you for interesting presentations. This question is for all of you, I guess. You have all referred to the international law's importance in national court cases, and in general, and especially Article 27. Within international law, it is known that document could be dynamically applied, changed over time. And my question is, are we now seeing that Article 27 are interpreted in another way than it was earlier? Is that a common trend or situation, more correct to say a situation, in these three Supreme Courts in the Nordic countries? Thank you.
I think I'll let the lawyers answer to that, but as I mentioned, I think this is the first time in Finland that the Article 27 was used in a court case where the Sami side won, so that is of course progress.
No, I don't think it's interpreted in another way. To have a juridical income, you should have a fact and then a rule upon it. So at least for Norway, it's the first time you have a case with an intervention who is similar to something what you could find in the practice of the Human Rights Committee. There have been only one case before where it has been seriously discussed, the Article 27, and that is the Josantesara case. And we can agree or not agree with the Supreme Court there, but at least it is a fact in the case which you cannot lead from, where you cannot use the case law from the Human Rights Committee. But if you're looking at the Fosen case, you can see that the Norwegian Supreme Court, they are not developing the law themselves. They are more or less just copying everything from the Puma. So therefore, I think it's difficult to make any conclusion on that. If we have more, when we'll have the next case, for example, the Øyfjellet case who come up soon, then we probably can start that analysis and see if there is any kind of development. Thanks.
Yeah.
Yeah, very briefly. To my knowledge, or my recollection, the Article 27 of the Common and Civil and Political Rights has not been applied frequently in Sweden. I can think of one case. It's a reindeer herding community that sought Ginjavare, that sought to stop the establishment of windmill parks in their territory based on Article 27 unsuccessfully. And I think it goes to, but beyond that, and Eivind can perhaps supplement, but I'm not aware of any other case. It goes a little bit to what Aslat so much aptly noted, that I think in Sweden the cases have, those few there are, have been more on territorial rights aspect rather than cultural rights.
And especially to Øyvind, you mentioned cumulative effects, and as I understood it, it was the court has considered cumulative effects in contrast to what courts have done earlier. And is that then change in the court's perspective?
Yes, on that question, I think I will say yes, because, and that is for two reasons. First, you have the so-called Gjert Tin case from Troms in 2017, where the Supreme Court say exactly opposite. There they said that it was a question about establishing cabins up in the mountains. And there was a lot of cabins from before, and the reindeer herders, they argued that you should look what is made here from before. And that time the Supreme Court said that to look at what has been done before and put it in the wider view, that is a question for the politicians, not for the court. This was a decision according to the Norwegian Reindeer Husbandry Act, but in any case it was about a provision who should prevent intervention in reindeer husbandry area. So I think Supreme Court has a development here. And then the other reason for that is the cumulative effect. Probably you can assist me there, Matthias, but I don't think you can read that clearly out from the Puma case.
I think that the cumulative, the Puma case was so clear. I think the cumulative effects comes from one of the Landsman cases, actually.
Yeah, perhaps.
Yeah.
Perhaps you're
On this technical question, I'm afraid I will have to end this session. And again, I would like to thank you all for coming to this seminar, and also for our speakers for your presentations, and for our viewers online. Thank you very much, and we'll continue the discussion, but offline. Have a nice evening. And a round of applause.